On May 14th, 2026, the U.S. Supreme Court held that a case against C.H. Robinson, who is arguably the largest food broker in the world, could be held liable for negligent retention of a shipper or carrier in transportation of a load. Why is that important? In the U.S., typically, all 50 states have the ability to regulate the safety of transportation within its own state. C.H. Robinson, again, the largest broker in the world, it's probably interstate, interworld, et cetera. They handle ship loads, they handle plane loads, they handle truckloads. And what we're talking about today is truckloads. They were a defendant in a case. So what happened is in 2017, unfortunately, a man in a parked vehicle was hit by a large truck, and it resulted in his leg being amputated. So a very serious injury. The plaintiff, who was injured, Montgomery, ended up suing not only the driver of the truck that ran into his parked vehicle, not only his employer who employed the trucker, but also C.H. Robinson, who employed both of them. So they hired this trucking company and this driver to haul this load, and it was going through Southern Illinois on Interstate 70. What happened in the case is, so C.H. Robinson was sued. They filed what they call a motion to dismiss or motion for summary judgment saying, hey, court, there's a federal statute under the FAAA that says that anything to do with trucking is preempted by federal law. So states stay out of that area of regulation. It's only the feds that can regulate trucking. And they made that argument to the U.S. District Court, and C.H. Robinson won. They went to the Seventh Circuit Court of Appeals, which is in Chicago, and they affirmed, saying, C.H. Robinson, you're out. There's no liability for you for negligently hiring a truck driver to broker your load. Well, the U.S. Supreme Court said, no, that's not true. There is a statute that regulates trucking cases. However, there's an exception. And that exception is very important. It allows states to regulate the safety of transportation in its own state. And this case fell within that exception. So Justice Barrett wrote the opinion, and every other justice, both the conservative wing and the liberal wing and all of them, joined in saying, that's right. There is no preemption for C.H. Robinson or any large broker who hires a trucking company to broker a load. Well, what does that mean to you? Well, that means there's going to be a lot more safety concerns for a C.H. Robinson when they're picking a carrier. In this case, in Montgomery, they hired a company with what they call a conditional rating. And a conditional rating is not a great rating for a trucking company. There's other ratings, including satisfactory. Conditional means that there were some problems with that carrier. And so some red flags going up, if you will. So does that mean you automatically win if you sue C.H. Robinson, if you're hit by a truck that was brokered? No, that does not mean that at all. It means that as a plaintiff, and I do this for a living, I represent plaintiffs or people injured by large trucks. If we sue a company like C.H. Robinson, we have to prove that they were negligent or breached a duty in hiring this specific carrier or this specific driver because they had a bad driving record or didn't meet specifications, that type of thing. And that negligence led to the injury to our clients. So that's what the case is about. So that's a big case. That was a defense used by C.H. Robinson and other brokers for years and years and years. And it was successful in a number of cases, but now it's no longer or ever be successful until the U.S. Supreme Court decides otherwise. I have firsthand knowledge of this case because back in 2009, my firm received a verdict against C.H. Robinson, where I believe we were one of the only cases to ever get a verdict against C.H. Robinson, along with my two co-counsel. On April 1st, 2004, my client, Bill Talek, was minding his own business on 55, the Stevenson in Chicagoland, and was in stop traffic when a large truck full of potatoes struck him and two other vehicles from behind at a very high rate of speed, probably 60, 70 miles an hour. Two gentlemen were killed in that crash. My client, William Talek, was severely injured and had a very bad permanent leg injury. And we ended up trying that case against not only the driver who probably fell asleep at the wheel, but also their employer, Dragonfly Express. But mainly the case was against C.H. Robinson, who brokered the load. And it was one of the first cases of its time to hold C.H. Robinson liable for the negligent conduct of a driver. I remember taking that case originally and was told that the maximum amount that we would recover is the $1 million total that was available under the trucking company and driver's liability policy, which would be split among the two widows and then my client, which mean that, after costs, they would basically get nothing. And I remember talking with a number of lawyers that had dealt with that litigation against C.H. Robinson before. In fact, there was a great lawyer down in Southern Illinois that provided me tons and tons of documents on that. And I immediately drove down there and met with him and got copies of all of his documents. And then I got to work. And for the next 5 years, I prepared for that case against C.H. Robinson and fought their motions to dismiss, motions for summary judgment, all those types of things. And we were able to get through all that and get to a trial of Bill Talek's peers as well as the widow's peers. And we were able to get a collective verdict of $23 million against C.H. Robinson. And they appealed that to the Illinois Appellate Court. And there's a case which is called Spurl and Talek, my client Talek, against C.H. Robinson. And there's an opinion that came out in Illinois in 2011, which is called, if you review this, it's the watershed case that held C.H. Robinson liable for the conduct of the driver. Now, our theory was a little different. Our theory was that C.H. Robinson was the principal and the driver and the company he worked for were the agent. And the jury believed that. And in Illinois, if the principal has the right to control the conduct of the agent, they can be held liable. And in that case, what had happened was there was a number of cases where C.H. Robinson had got out by motions, which means there was no jury trial, there was no nothing, because they were able to convince courts that, hey, we're like FedEx, we're just hiring a company to deliver packages, and it's not us, we're not doing it. We're an independent contractor. And in fact, there was a contract actually between the trucking company and C.H. Robinson, which said, hey, we're C.H. Robinson. We're not liable for anything. We're an independent contractor, all those types of things. And so a lot of people went away thinking we can never hold C.H. Robinson liable. Well, I wanted to dig further. And so I did. And I actually found out a lot of information about who actually controlled this load that was from Idaho all the way to Illinois, ended up in I-55, almost at its destination in Bolingbrook, where it was delivering a full truck full of Idaho potatoes. Some of the factors that were involved in that case were that C.H. Robinson controlled from the beginning how that was going down. First of all, it had to be a refrigerated load. The driver could be fined for being behind schedule. They controlled that the driver had to call them every 24 hours. They controlled the gas payments. They controlled a number of different things. And the jury agreed with us that they were a principal agent. Now, in the Montgomery case, they're talking about a different theory, which is that there was a negligent selection of the carrier, which led to liability. And we could have alleged that too, and I think been successful on that theory as well. But I think we would have been in the Supreme Court probably about 4 years earlier or 5 years earlier than the Montgomery case. So I'm glad that worked out. And for the public, for you guys, it's a very important case because typically a lot of these trucking companies are penniless. They have no money. All they have is the truck, which they owe a lot of money on. They have very low liability insurance. Typically, the maximum amount that's required for liability insurance is $750,000. A lot of them have $1 million policies. But when you have this type of devastation, this type of injury, this type of change. I mean, there was 2 widows, and then my client was in his 30s, could never walk normal again, could never roam with his kids, could never, etc. $1 million split among 3 people is ridiculous. So this opens it up to a much more safer highway, a much more safer interstate highway, a much more safer selection of trucking companies because they're going to be held to that standard, and better for the consumer or the folks that are injured by these folks, that there'll be actual responsible parties who controlled this, who make money off these transactions. Those people will be held accountable. Trucking brokers don't get a pass on these types of cases anymore. They're not going to be able to hide behind an independent contractor agreement if they had any involvement in selecting a horrific carrier, if they had horrible policies and procedures for selecting unfit drivers. The drivers that are out there, most of them are great drivers. Don't get me wrong. The number one job in America is a truck driver. I have a high respect for truck drivers in America. But there's some fly-by-night ones too that have not passed the proper tests, have never had driving tests, and brokers are no longer going to be able to pass on the liability for paying damages for negligent selection. And so this is a nice win for the American public in the Montgomery case, which was decided in May of 2026 by a unanimous Supreme Court. So very happy to hear that. For more information on these types of cases or other updates, feel free to subscribe to our YouTube channel at Shannon Law Group. We're going to be providing these updates continuously, and we want to make sure that you're aware of them and that you're able to understand exactly who's at fault, who's not at fault in our American justice system. We're with you.